The next matter to come before the court this morning is In Re RS. Both sides will have 15 minutes to present oral arguments this morning. The appellant may reserve up to 5 minutes for rebuttal. So if you are the appellant in this case and would like to reserve that time, if you let me know when you get started. I'm keeping the clock, and so I can keep you apprised of the passage of time if you're entering into that 5 minutes or any amount of time that you reserve. I would also note and remind counsel that this case involves a juvenile and that we record our oral arguments and post them on YouTube. So if you could kindly not use names, even using the terms mother or father or other family members in terms of their designation instead of their names, that will assist us in keeping confidential information off of all of throughout the case. We greatly appreciate it. We've read the briefs and we are ready to see when you are.
Thank you, Your Honor. If it pleases the court. Good morning to everybody. And my esteemed colleague, I'm here on behalf of appellant LS. This concerns the minor child RS. And I would like to reserve 5 minutes. Frankly, I don't think I'm going to spend more than that much time because it's a very narrow issue and I don't have all that much to say to add, but would like a chance to address the court. Basically, as I've set forth in the brief, this case involved a custody and visitation issue. I'm here only on the visitation issue, as I have set forth in the brief. And basically, our controversy or issue involves the trial court's modifying the visitation of this child and putting mother on a restricted visitation schedule with supervised visits limited to a certain number of hours a week. And of course, they did that allegedly based on the child's best interest, based on certain allegations that they claim were made and findings that they made that we don't believe are true or supported. So, having said that, my arguments are basically two very simple arguments, and one really hinges upon the other. So to get on with it, I think, A, the trial court abused its discretion by overruling mom's objection to the magistrate's decision, which I set forth. Secondly, and this really is part of one but hinges and explains why I thought number one, which is the trial court's factual findings that mom held herself out as the legal custodian and that she did not believe the allegations of abuse made allegedly by the minor child were not supported by competent, credible evidence. As the court knows, this child, RS, was adjudicated as a dependent child. Custody had been given, I think in 2013, to maternal aunt EW. The motion that's in question was filed July 10th, 2015 by the Children's Services Board to modify the visits based on a series of alleged behavioral issues that began with mom's, quote, unsupervised visits. There were certain allegations that were made. I don't really want to get into specifics because of the nature of them, if that's all right with the court, since this is going to go and they were put in there, but behaviors of certain body parts being put in someone's butt, etc., and so forth. And this went on where there were 4 distinct hearing dates: July 13th, July 17th, August 4th, August 18th, with finally a magistrate's decision being issued on August 31st. And basically, mom had taken the child to the hospital, to the emergency room. She had received a referral for a care center for follow-up, and instead she brought the child back to Akron Children's Medical Center a second time. The issue comes really as to what the court said, mom said, versus what was really said and what is supported by the evidence. So to cut to the chase as to the issues, and I highlighted these, I think beginning with page 5 of my brief, just should the court wish to follow along. I I stated, and I'm stating again, that the judgment entry concurring with the magistrate's decision and overruling mom's objection to magistrate's decision was an abuse of discretion, giving deference to magistrate's determination that mother's testimony was less credible than aunt and counselor. While we understand that trial court and a magistrate have absolutely the right to do that, in this case, looking at the transcript, we would respectfully disagree with the conclusions they reached, not with the principle, but with exactly what went on here. The record contained testimony to suggest that far from deliberately misstating the nature of her parental rights towards hospital staff, staff members probably assumed, which was the intake workers at Children's Hospital, that biological mom was the custodial parent. There's nothing in there that my client or mom said, I have custody. The testimony from the hospital staff was contradictory and ambiguous as to the statements mom made when she called the hospital June 29, 2015. RS's caseworker, the child, testified that a Miss JM, which was the hospital social worker, I'm abbreviating on purpose, was trying to get more information from mother, and she had asked her who had custody of RS. And she stated that she was the one who had custody, but that RS did spend a couple days a week. However, in a later transcript at the next hearing, August 4th, lines 104 to 106, the social worker, JM, recanted the statement when she claimed or testified, I did not directly ask her if she had custody, quote, I just assumed she did. And that's an understandable mistake that anybody can make. Biological mother walks in. I think most of us can make an assumption, whether we should or shouldn't, that it's your child, you have custody, until somebody says otherwise. And this same social worker, JM, also admitted that mother said that aunt had the child a couple of nights a week, but that, quote, it's possible mom may have misunderstood that. The CSB worker had testified there was a concern about the way that mother had portrayed herself as the legal custodian when she was called to the hospital. Reviewing the assessment, though, from July 3rd, 2015 visit, this same social worker at CSB testified the mother reported as the child being in the aunt's custody, again, transcript August 18th at 198. And then other testimony, August 18th, transcript 2216. I didn't say her name, but I said his aunt had him the majority of the time. I had him a couple days a week. That L, his aunt, had him the rest. So again, we respectfully submit the court did not have competent, credible evidence to find that mother held herself out as the child's custodian. Again, and I think the most likely explanation was just a simple misunderstanding that biological mother would have custody. And then the next thing that was also disturbing was we think that this decision to give the magistrate's weight of credibility against mother was arbitrary and unreasonable for those reasons, because that wasn't correct what was actually said. And that the allegation that mother made multiple reports despite admitting she does not believe the allegations, which is what the child said about certain body parts, the record also demonstrates a lack of competent, credible evidence to support the conclusion. And again, I have set forth on page 7 that the record appears to be based on an exchange between the court and the mother. And without going through all of that, which I realize that this esteemed panel can read, I think what's operative is the last sentence that says, witness. The only thing that I said is I don't know where he's getting this from. So, and if you see transcript, August 18th, 245 and 247, mother actually stated the opposite of the findings contained in the judgment entry, claiming that she didn't say those exact words. And again, I don't know where he's getting this from. We respectfully submit mother's testimony should have carried more evidentiary weight than the hospital notes or the records that could have easily misstated or misconstrued mother's statements. It is no surprise to this court that something that's written incorrectly one time gets republished in medical records. We've seen it all over and over and over again, whether it's in a personal injury case, a medical malpractice case, or a child custody case. We've seen it over and over. It does happen. This is particularly true given the facts and circumstances already in evidence, where J.M. assumed mother stated she had custody in that misunderstanding.
You have about 5.5 minutes remaining, so.
Okay.
Just letting you know.
I will say it was interesting to note that mother was not questioned on the exact content of these records, nor were any exact statements quoted during mother's testimony. Mother was forced to remember what she had told the staff 6.5 weeks ago. In contrast, the hospital staff members had a chance to review their notes to accurately refresh their recollection of what took place. Given these circumstances, I respectfully submit there is no clear and convincing evidence to support the trial court's conclusion that mother admitted she does not believe the allegations. Therefore, the trial court's decision to adopt magistrate's credibility determination, giving less weight to mother's testimony, was, we respectfully submit, arbitrary, unconscionable, and unreasonable, therefore an abuse of discretion. And I thank you.
May it please the court, counsel. Heaven D. Martino on behalf of Summit County Children's Services Board, we are asking that this court affirm the decision of the trial court where the juvenile court judge affirmed the magistrate's decision with regard to a modification of visitation. At the heart of this is a modification of a prior visitation order. These orders are generally not deemed to be final appealable orders. The agency would argue at the first that it is not a final appealable order and the matter should be dismissed on that basis. In the alternative, the agency contends that what this court is faced with is an issue of whether the modification was proper. The trial court followed the applicable law when it examined whether mother's visitation rights should be more restricted than they had been after the child had visits with mother and began to act out, misbehave, their allegations, sexually inappropriate comments by the child. All of the allegations that were reported to the agency were investigated and were determined to be unsubstantiated. There is no evidence in the record that the trial court abused its discretion simply because it found the the aunt, who is the caregiver, and the other witnesses put forth by the agency more credible than mother. The appellant has to show more than simply, we think that the court should have found our testimony more credible to show that there's an abuse of discretion. The journal entry specifically enumerates the pages of the transcript on which Judge Linda Tucci Teodosio based her findings. There's no evidence to contradict that. Therefore, there's no evidence to find that the trial court abused its discretion in making the determination that it did. Furthermore, this issue about whether mother held herself out to be the custodian or not is really not determinative of the issue of whether this child should have modified visitation, specifically supervised visitation with mother. That really does not go to the heart of the issue, which is whether the modification was correctly determined and granted by the trial court. If there are no other questions, I would rest on the brief.
Counsel, you have about 4.5 minutes remaining of rebuttal time if you wish to utilize your.
I have 30 seconds of something to say, and that's it, if I may. Thank you. I believe in short and simple. I appreciate the comments of my esteemed colleague. The only comment I would make is we're very fortunate to have very good judiciary in our county, and I'm proud to be here. The only thing, when I took a careful look through, Judge Teodosio was very careful in what she did. but if you take a hard look at the transcript, it's still inaccurate. What the workers said was said, and what was actually said is not correct. And that basically is just unjust to Mother, you know? And if you think about it, how easy would it be to remand this and straighten some of these things out? It would be a very simple thing. That would be my greatest wish in this case, is to get it right. Client had court-appointed counsel first, and they did the best they could with the limited resources, but there were a lot of things that, just as comments this pastor, she's available. I would love to have a chance to get this right and straighten it out with Judge Teodosio if we're given an opportunity. Thank you.
Hang on. Counsel? I believe there's a question from the.
Oh, excuse me, Your Honor, forgive me.
You want to address the final appealable order issue that was brought up?
Your Honor, I had thought that was resolved I thought it was based on the custody, that this was not a final appealable because of the other custody decision. And that was the reason for the consolidation here with that. So forgive me, but I had looked at that this morning to make sure and thought that that was addressed. Excuse me.
Additional questions based on that? Okay, thank you both for your
Thank you very
presentations
much.
today. Court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website.